As someone deeply concerned about international human rights issues, one of my favorite courses to teach at Penn State was international law. This video is about international humanitarian law, its development, and issues that face it. International law developed in desperate times. Among its earliest advocates was Dutch humanist thinker Hugo Grotius, who lived during the height of the wars of religion in Europe. Unfortunately, the scale and lethality of wars increased, beginning particularly in the Napoleonic era and continuing to the middle of the 1800s. At that time, a number of wars occurred which brought attention to humanitarian need. They included the American Civil War, the Crimean War, and the wars which led to Italy's unification. Swiss businessman Henri Dunant was visiting northern Italy when he was caught up in the Battle of Solferino. In the aftermath of the battle, thousands of wounded were left on the battlefield. He bought cloth for bandages, rented barns for field hospitals, and gradually was able to treat many hundreds of wounded. Returning home to Geneva, Switzerland, he wrote A Memory of Solferino, an influential book which recounted his experiences. He established an international organization everyone knows today, the Red Cross. He simply took the flag of his native Switzerland and reversed it, taking a white cross on a red background and reversing it to a red cross on a white background. Later, the British Red Cross was set up by Florence Nightingale and the American Red Cross by Clara Barton. The First World War proved even more horrific. Among the many problems that developed were those of displaced people. Fridtjof Nansen was an Arctic explorer who gained fame far beyond his native Norway. After the First World War, he had a second career and became the League of Nations' first Commissioner of Refugees. Particularly concerned about stateless persons, he was able to issue identity documents known as Nansen passports. Quite a few of these stateless people would later become famous. The very first refugee situation to achieve international attention was that of the Belgians who fled the German advance at the beginning of the First World War. In Britain and America and elsewhere, their plight was described in posters, artwork, pamphlets, and books. The terms used to define people fleeing were standardized. The term migrant is probably the most indescript. It describes someone who simply changes their residence. A stateless person, fortunately, no longer exists. Statelessness was outlawed by international conventions which forbade any government to deny nationality to anyone who couldn't claim an alternative nationality. The term asylum seeker simply means someone who is fleeing. The most well-defined term is refugee, which describes a person fleeing in fear of his or her life. The term refugee is a political one. There's no such thing as an economic refugee. In fact, those are asylum seekers. In order to qualify as a refugee, they need to cross an international border. As time went on, particularly in the 21st century, increasingly many people fled within their own countries. They are known as IDPs, or internally displaced persons. On this slide, you can see people who have been displaced throughout history. In the lower left, Huguenot refugees in southern France. In the lower right, Czechs fleeing the German invasion. In the upper right, Armenians. And then German children displaced by the Second World War. World War II led to increasing emphasis on human rights. Following the war, The newly established United Nations named Eleanor Roosevelt, the widow of the late President Franklin Roosevelt, to head its Human Rights Committee. This committee drafted the Universal Declaration of Human Rights, whose primary author was French legal scholar René Cassin. Another important figure at this time was Raphael Lemkin, who defined the concept of genocide. Here's an old CBS newscast on this subject.
Genocide is a new word combining the Greek word genos meaning race or group, with the root of the Latin sidere meaning to kill. Dr. Raphael Lemkin, who is a professor of law at Yale University and specializing in teaching matters about the United Nations. Dr. Lemkin is the man who created the word genocide. Dr. Lemkin, could you give us a little background on how you came to be interested in this genocide?
Became interested in genocide because it happened so many times. It happened to the Armenians, and after the Armenians, Hitler took action.
Lemkin became the leading force behind the drafting and adoption of the International Convention on the Prevention and Punishment of the Crime of Genocide, adopted unanimously by the United Nations General Assembly in Paris on December 9, 1948.
I would urge, and I think that's the spirit, the unanimous view of the Assembly, that this convention be signed by all states, ratified by all parliaments at the earliest date.
Because Raphael Lemkin was a Polish Jew, many people think that he was describing the Holocaust in defining genocide. However, his research was on the Armenian genocide, which occurred during the First World War. Nevertheless, for many, the Holocaust is the definitive genocide. Following the defeat of the Axis powers in the Second World War, military tribunals were set up, most famously in Nuremberg, but also in Tokyo, where they tried many war criminals, including Hermann Goering, Albert Speer, Rudolf Hess, and Japanese Prime Minister Hideki Tojo. However, at this time, genocide had not yet been legally defined, so these major Axis figures were tried for war crimes and crimes against humanity. War crimes are grave breaches of the four Geneva Conventions. Signed in 1864, the First Geneva Convention covers wounded and ill combatants. The Second Geneva Convention, signed in 1907, covers combatants at sea who are wounded, ill, or shipwrecked. The Third Geneva Convention, signed in 1929, covers prisoners of war. It provides the famous statement that prisoners are only required to turn over their name, rank, and serial number. In addition to this, prisoners are not to be considered hostages. Finally, the Fourth Geneva Convention in 1949 covers civilians. The Geneva Conventions cover only crimes that occurred during wartime. It took many years before the United Nations recognized crimes of aggression, or crimes which cause wars, which only were recognized in 2018. These could be by either governments or non-state parties. Over many years, crimes against humanity were recognized. They eventually were enumerated as 15 serious violations. These can occur against civilian populations either in wartime or peace. The listing you see here is quoted from the Rome Statute establishing the International Criminal Court. Violations can include murder, extermination, enslavement, deportation, forcible transfers of population, imprisonment or other severe deprivation of physical liberty, torture, rape, sexual slavery, enforced prostitution, forced pregnancy, enforced sterilization, persecution against any identifiable group or collectivity, the enforced disappearance of persons, apartheid, segregation, and other crimes regarded as inhumane. As the United Nations was established, it immediately faced two major crises which put it to test and which still remain with us today. The first was the partition of British India in 1948, which divided India into India as we know it today and Pakistan. Eventually, East Pakistan split away in 1971 as Bangladesh. An ongoing conflict exists between the two powers, which today both have nuclear weapons. The second crisis that begot the newly established United Nations was that of Palestine, when the British gave up their mandate in 1948. The UN had a partition plan to divide the area between Jews and Arabs, but it led to war. Ultimately, many Palestinians were displaced, which led to the establishment of the United Nations Relief Work Administration, the oldest UN agency not carried over from the League of Nations. More recent refugee situations have followed wars and humanitarian crises in Afghanistan, Ethiopia, Sudan, South Sudan, Rwanda, and Syria. Refugees are typically housed in camps. This is an easy way to provide accountability and control. However, it has many problems, not to say the least, the crowding and often unsanitary conditions. This was particularly true in refugee camps in Bangladesh, housing Rohingya Muslims fleeing from Burma. Fire ravaged through the camp, destroying many dwellings and killing many people. The Convention on the Prevention and Punishment of the Crime of Genocide, which I mentioned earlier, is divided into 19 articles. I will be looking at the first 5, which effectively define this crime. Article 2 precisely defines this crime as meaning any of the following acts committed with intent to destroy in whole or in part a national, ethnical, racial, or religious group. These include, in declining order of severity, killing members of the group, causing serious bodily or mental harm to members of the group, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, imposing measures intended to prevent births within the group, and forcibly transferring children of the group to another group. While we typically think of genocide as mass murder, in fact, points D and E involve eliminating a group without killing anyone. Selected compulsory sterilizations in Indira Gandhi's India is an example of D. An example of point E is a long-standing case in Australia in which Aboriginal groups have opposed the historic policies of Australian governments transferring their children to white families. The key factor which proves a case of genocide is, in fact, the showing of intent. Article 3 enumerates the acts which are punishable under the Convention. They include genocide, conspiracy to commit genocide, direct and public incitement to commit genocide, attempt to commit genocide, and complicity in genocide. This article brings out a unique aspect in the Convention, and that is the fact that genocide does not need to be a completed act. There's no such thing as attempted genocide. An attempt to commit genocide is genocide. Wisely, the framers of the Convention chose this wording in order to give the Convention force and not to allow a group to be eliminated before action could be taken. This is a rather unique crime. In order to be convicted of murder, someone needs to kill someone. In order to be convicted of robbery, someone needs to steal. but in order to be convicted of genocide, one only needs to attempt it. Article 3, point C, is particularly interesting because the direct and public incitement to commit genocide can include many things, ranging from the charter of Hamas to the hateful statements made by Israeli settler groups to even protests that have been lodged on American college campuses. Article 4 importantly notes, persons committing genocide or any of the other acts enumerated in Article 3 shall be punished, whether they are constitutional responsible rulers, public officials, or private individuals. Very clearly, this was meant to prosecute individual persons. This was the case in the tribunals that were held in former Yugoslavia and Rwanda. One of the unfortunate aspects of the South African case against Israel is that Israel is collectively punished, which flies in the face of the whole spirit of the convention. Article 5 mandates that all signatories to the convention should incorporate it into their constitutions and legislation. You may have noticed I skipped over Article 1. Article 1 has a very powerful wording. The contracting parties confirm that genocide, whether committed in time of peace or in time of war, is a crime under international law which they undertake to prevent and punish. In actual fact, this is an escape clause that has been unfortunately used by many governments, including the Clinton administration, which avoided intervening in Rwanda. Similarly, the situation in Srebrenica in Bosnia was not declared a genocide until 10 years after it had happened. Historically, population removals have been used to clarify ethnic lines. Such actions go back to ancient times. Following a period of intense conflict immediately after the First World War, Greece and Turkey agreed to exchange populations. 1.5 million Greeks were moved from Turkish areas, and 0.5 million Turks were moved from Greece. While memories of this are still very bitter, it clarified ethnic lines, which led to a situation in which Greece and Turkey, though in conflict, did not have another hot war. A more severe example of population removals followed the Second World War, when over 11 million Germans and 5 million Poles were moved, largely at the behest of the Soviet Union. The animated map on the lower right shows how German populations were forcibly shifted westwards. While population removals and exchanges are almost never desirable, they do clarify ethnic lines. However, this proved to be impossible in the checkerboard of ethnic relations that was Yugoslavia when it broke up in the 1990s. The term ethnic cleansing was often used for many years in the Balkans. You can see it in its Croatian form here. However, during the demise of Yugoslavia, it became a popularized media term. A UN commission of experts investigating human rights violations in former Yugoslavia issued a report which defined ethnic cleansing as rendering an area ethnically homogeneous by using force or intimidation to remove persons of given groups from the area. They shortly further defined the concept as a purposeful policy designed by one ethnic or religious group to remove by violent and terror-inspiring means the civilian population of another ethnic or religious group from a certain geographical area. Many investigators, scholars, and jurists would later point out that the targeted groups were often seen as undesirable. Unfortunately, the Commission of Experts blurred the distinction between ethnic cleansing and other crimes by saying that it was covered by crimes against humanity, war crimes, and the Genocide Convention. Therefore, it had no separate legal definition. However, I strongly feel it should be a separate crime. One case that I would argue meets the definition of ethnic cleansing, but not necessarily genocide, is that of the western Sudanese region of Darfur, where people were moved from their property in order to deny them of their assets, rather than to exterminate them. Darfur is a case in point of how human rights issues need to be pursued legally and dispassionately, without emotive responses. Like the term genocide, ethnic cleansing can be used in very imprecise ways, including hateful ones. A white supremacist group issued a video game called Ethnic Cleansing, in which a race war is conducted by white supremacists shooting blacks and Latinos, going down into the subways and eventually uncovering a bunker when none other than Benjamin Netanyahu and a cabal of Jews is controlling the world. A British cowboy and Indian playset is confusingly called both ethnic cleansing and genocidal. Is urban gentrification ethnic cleansing? Is abortion ethnic cleansing? Much greater definition is required. I'm not suggesting we eliminate the crime of genocide. However, it needs to be reserved for those who proudly are willing to admit what they have done. In today's polarized political world, human rights issues are often seen as politically charged, and particularly left-wing. However, this is not always the case. America's national parks were established largely based on the ideas of progressive John Muir, who envisioned a pristine wilderness devoid of human habitation. This led to a massive expulsion of all Native American groups from federal lands, with the only exceptions being in Alaska. Legally defining ethnic cleansing would allow the pursuit of various crimes which could be better determined on the basis of measures of behavior rather than on the strict definition of genocide based upon intent.